Here, the state's attorney's present, defendant and defense counsel are present. We have met informally with regard to some changes in the court's proposed charge. I've given you each a copy of the charge with those agreed upon changes. Are there any other requested additions or corrections or objections? I'll give y'all both just a second to make sure. I just found something. On page 4 under parole, it has that example, which says if he's, and it's really just an example, but it says if he's sentenced to 4, then he has to do 2. It just is confusing because he can't be sentenced.
And I hate that, but it's actually part of the quotated language that the statute says shall be included.
It is. Okay, I'll just leave.
I don't think we can
Yeah.
submit it.
Okay.
I guess we could
It's just
without
that,
objection, but
well, I don't think, I mean, it's not saying he's going to get that. It's just explaining to them how to do math. So, okay, never mind then. All right, so anything else with regard to the charge, Mr. Smith?
no, Judge.
Mr. Vasquez?
Judge, is there, well, never mind, just found it. Sorry. Sorry.
You're good. It's all good then?
Can I have one more minute here?
Yes, sir. On page 3,
Yeah, page 3.
where it says the state has accused the defendant of having been convicted of a felony twice before, should I say of a felony at least once before or something like that?
I would take the twice out. I would say of at least.
What do you think it should say?
Here's the defendant of having been convicted of.
At least once before. That's the language that we keep using, is at least once before,
Right.
right?
Yeah, a felony. I just went back to that. So I don't know if having been previously convicted of a felony, of at least one felony. Does that sound all right? It's not what we've been saying, though.
No.
Just for consistency, I guess.
I mean, they both mean the same thing. I'm gonna use the at least just because we keep you, so it reads, the way I have it, the state has accused the defendant of having been convicted of a felony at least once before. That's what it says everywhere else.
Can you lose the at least, Your Honor?
But we've been putting at least everywhere else because it only requires one. And so I think that keeps it consistent with the other ones. Unless y'all both agree to take that out, but I think we've,
Just keeps it consistent all the way through the charge if you do it that way.
okay. All right, so there's that. What else?
I'm sure we'll see one about 3/4.
As soon as I'm reading it, I know. So I need to print page 3. Stapler, taker, I need to get one of these for my drawer here. Here should be page 3. Okay, with that modification now, are there any requested additions, corrections, or objections?
Not mistaken.
Not from the defense,
All right. Anything else before we bring the jury in then?
Not mistaken.
Mr. Vasquez, anything else?
No, Your Honor.
All right, you can bring the jury in. Good morning. Let the record reflect that the jury is seated, state's attorney's present, defendant and defense counsel are present. And so let's get caught up on where we are from yesterday. The jury reached a verdict of guilty in cause number 23 DCCR 0329. At this time, I accept your verdict, find you, Mr. Westbrooks, guilty of the offense of murder. Mr. Smith, you may read the remainder of the indictment. Mr. Westbrooks, if you'll please rise.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted of the felony of burglary of a habitation, second degree, on April 9, 2012, in cause number 10-08944 in the Criminal District Court of Jefferson County, Texas.
And Mr. Westbrooks, is that true or not true?
True.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term, that before the commission of the primary offense, the defendant was finally convicted of the felony of robbery, second degree, and on April 29, 2013, in cause number 12-14152 in the Criminal District Court of Jefferson County, Texas.
And is that prior conviction true or not true?
True.
All right, thank you, sir. You can have a seat. All right, Mr. Smith, do you wish to make an opening statement?
Just briefly, Judge.
Go ahead.
Ladies and gentlemen, I want to thank you again for your time and your verdict. I assure you it was a proper verdict under the law and the facts and the evidence that was given to you in this case. We talked about the separate stages in a criminal trial when we were in Rhode Island. And I told you in the first phase, it's not the time for sympathy, emotion, or compassion. It is simply to determine if the facts amount to a crime. If so, then guilty. If not, then not guilty. Guilt is over. Now we're into the punishment phase. This is where you as jurors help me, help all prosecutors out, because this is the benchmark part. This is the part where we know what a jury says should happen to a person with this kind of criminal history, commits this kind of crime in our community, what should happen. So that becomes the job now. And for that, you can take in the totality of the circumstances. You can take in sympathy, emotion, or lack thereof, good things that he's done, bad things that he's done, all of that, that big picture. And he can be punished based on all of that, not just on that short window of his conduct at that time. Okay? So I just want to let you know that, and thank you again for your verdict. We're going to give you some more evidence, and then we'll get you back to deliberating on the function in this case. Thank you.
Thank you, Mr. Smith. Mr. Vasquez, do you wish to make an opening statement?
Very briefly, Your Honor. I joined Mr. Smith in
thanking you for your service. Respect your verdict, and be back to talk to you again during closing argument.
All right, thank you, Mr. Vasquez. Mr. Smith, you may call your first witness.
We call Troy Robinson.
Good morning, sir.
Morning.
Do you swear or affirm the testimony you're going to give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. You can have a seat. You may proceed.
Good morning. Would you state your name and spell it for the court, please?
Troy, Troy, Robinson.
And what is your occupation?
I'm an investigator for the Jefferson County District Attorney's Office.
How long have you been so employed?
A little bit over 7 years with the District Attorney.
Are you a certified peace officer in the state of Texas?
Yes, I am. I hold a master's certification.
And what are your duties as an investigator for the district attorney's office?
So our duties are to assist the attorneys in preparation for trial, look over some of the case files, obtain statements, evidence, locate witnesses, serve subpoenas, testify in court, and particularly for my case, I do some fingerprint comparison work.
Okay. And prior to being at the district attorney's office, where were you employed?
I was at Port Arthur PD for 20 years. I retired from there and then moved over to here at the DA's office.
So are you a fingerprint expert?
Yes, I have been certified as one in this court.
What training and background do you have that qualifies you as an expert in the area of fingerprint identification?
So in 2018, October 2018, I attended a 40-hour core course at Texas Forensic Associates. It's a fingerprint comparison school. Once you complete the course, obtain your certification, you maintain some regular training, and basically we'll call it like testifying in court is part of that. And I've testified in the 252nd District Court on many occasions.
That was going to be my next question. Have you testified before as an expert in district courts here in Jefferson County?
Yes, I have.
Many occasions?
Yes, I have.
What is a fingerprint?
So a fingerprint is a friction on your fingertips or your thumb. You have friction ridges. On the friction ridges are basically oils that your body produces. When you touch something, it's possible to leave a fingerprint, which is considered a latent print. Now, latent print is invisible to the eye, so you can't really see it. So what you have to do is use like chemicals, powders, things of that nature to bring the print visible, so you can like obtain it from whatever surface or object it may be on.
Have you ever found two people to have the same fingerprints?
No, your fingerprint is a biologically unique to you yourself.
Have you ever heard of anybody having two different people having the same fingerprint?
No, I have not.
What is an inked print?
So an ink print is exactly what it states. We basically take a pad, it has some ink on it. When you touch your fingertip to it and you put it on a piece of paper or any other substance, it's going to leave a visual marking of the fingerprint from the ink itself.
Approach that.
Yes, sir.
Show us the marked as State's Exhibit number 22. I'll ask if you recognize that.
Yes, I do.
What is that?
So this is a fingerprint card that I took yesterday from Mr. Paul Westbrook Jr.
So you took and inked his fingerprint, or his fingers, and then put them on that card, put the prints on that card?
That is correct. I actually had to take 3 fingerprints. We mostly in court use the thumb, the right thumb, the left thumb. I had to take the right thumb twice. The first one was kind of light and I didn't really like it. So I took 2 of the right thumb and 1 of the left thumb. And that's on its State's Exhibit 22.
Okay. Now at this time, we'd offer State's Exhibit 22 into evidence.
No objection to 22, Your Honor. I was actually present when Ms. Robinson did his work.
Thank you, Mr. Vasquez. 22 is admitted.
I guess, so you made that yesterday. Do you see in the courtroom today the person whose inked fingerprints appear on that card that's been marked State's Exhibit number 22?
Yes, sir, I do.
Would you point him out to the jury, please?
The gentleman sitting over next to Mr. Vasquez.
You're gonna let the record reflect he's identified the defendant in this case.
The record will so reflect.
Now, let me show you what's been marked as State's Exhibit number 33. Can you identify that?
Yes, sir, I can.
What is it?
So this is a judgment in the state of Texas versus Paul Edward Westbrooks, AKA Paul Edward Westbrooks Jr., under the case number of 10-08944 in the Criminal District Court of Jefferson County, Texas.
Does it contain a set of fingerprints made by the defendant that was sent to the penitentiary as reflected in that certified copy?
Yes, in the certified copy, there is a right thumbprint from the comparison of the judgment in the fingerprint card. It is Paul Edward Westbrooks, AKA Paul Edward Westbrooks Jr., which was a judgment of guilt for burglary of a habitation. Date of the judgment entered was 4/9/12. The offense date was 6/28. Sorry, 1/29/2010. And he received 5 years in TDCJ.
Have you compared the inked fingerprints on State's Exhibit number 22 with the inked fingerprints in State's Exhibit number 33?
Yes, the fingerprint on State's Exhibit 22 and 33 are exact.
Okay, so your opinion is that the fingerprints were made by the same individual?
They are.
Do you have those, when you do a comparison, do you often compare it, but do you have it verified by other fingerprint experts?
Sometimes we do, sometimes we don't. It depends on our manpower. Currently, we're a little short on manpower, so for this one here, this was completely done on my own.
Okay. Was this a difficult comparison?
No, it was not.
Show you what's being marked State's. Well, actually, Judge, at this time we'd offer State's Exhibit number 33 into evidence.
Your Honor, Mr. Westbrook is admitted to this prior earlier. We have no objection.
State's 33 is admitted.
We'll show you what's been marked State's Exhibit 34. Ask if you recognize that.
Yes, I do.
What is it?
This is a judgment of the state of Texas versus Paul Edward Westbrooks Jr., AKA Paul Westbrooks Jr., AKA Paul Edward Westbrooks Jr., case number 12-14152 in the Criminal District Court of Jefferson County, Texas.
And does it contain a set of fingerprints made by Mr. Westbrooks, who was sent to the penitentiary as reflected in that certified copy?
Yes, it does.
Have you compared the inked fingerprints on State's 22 with the inked print in State's Exhibit 34?
Yes, I have.
And do you have an opinion as to whether the fingerprints were made by the same individual?
They are.
What was the sentence received in that?
So on this judgment, the defendant was convicted of robbery. The date of the offense was 11/21/2011. The date the judgment was entered was 4/29/2013. It was a second-degree felony, and he received a term of 12 years in institutional division. It doesn't list it as TDCJ. Oh, yes, it does. Down on punishment, place, and confinement. Sorry.
Okay. So he received 12 years in that case.
That's correct.
You show it's been marked, or actually, at this time we'd offer State's Exhibit 34 into evidence. Certified copy of the public record.
Mr. Westbrook has put it through to this one as well, Your Honor. We have no objection.
States 34 is admitted.
You show what's been marked State's Exhibit 35. Do you recognize that?
Yes, sir, I do.
And what is it?
This is a judgment, the state of Texas versus Paul Westbrooks Jr., AKA Paul Edward Westbrooks Jr., case number 12-13415 in the Criminal District Court of Jefferson County, Texas.
And does it contain a set of fingerprints made by Mr. Westbrooks, who was sent to the penitentiary for?
It contains a thumbprint, yes.
Have you compared the inked fingerprint on State's Exhibit 22 with the inked fingerprint in State's Exhibit number 35?
Yes, I have.
And do you have an opinion as to whether or not those fingerprints are made by the same person?
They are.
And what was that conviction for?
So this conviction is a state jail felony of evading arrest, detention with previous convictions. The offense date was 1/23/2012. Date of judgment 4/9/2012. And he received a 2-year sentence to run concurrently with another case in the Jefferson County, out of Jefferson County, Texas.
This time we'd offer State's Exhibit 35 into evidence.
No objection to State's 35, Your Honor.
It's admitted.
And you look at marked State's Exhibit 36. Do you recognize that?
I do.
And what is it?
It's a judgment, the state of Texas versus Paul Edward Westbrook Jr., AKA Paul Westbrook Jr., case number 12-13598 in the Criminal District Court of Jefferson County, Texas.
Does it contain a set of fingerprints made by Mr. Westbrooks, who was sent to the penitentiary for that offense?
Yes, it does.
And have you compared the inked fingerprints in State's Exhibit 22 with the inked fingerprint in State's Exhibit 36?
Yes, I have.
And do you have an opinion as to whether or not those fingerprints were made by the same individual?
They are.
And what was the sentence received in that case?
So this is evading arrest, detention with previous conviction. Date of offense 1/24/2012. Date of judgment entered 4/9/2012. And this was confinement in state jail for a term of 2 years to run concurrently with other cases.
This time we'd offer State's Exhibit 36 into evidence.
No objection to State's 36, Your Honor.
States 36 is admitted.
Permission to publish this to the jury.
Yes, sir.
Last witness.
Thank you, Mr. Smith. Mr. Vasquez, any questions?
No questions for this witness, Your Honor.
Any objection to Investigator Robinson being excused?
No, Your Honor.
Okay.
Thank you, sir. You may call your next witness. At this time, you have heard all the evidence, obviously in the guilt-innocence phase and the additional evidence in the punishment phase of the trial. The next part is just like the previously. I have the court's charge. It is ready. I'm going to read the charge to you. Then you will hear closing argument by counsel, and the case will be given to you for deliberation. Cause number 23, DCCR 0329, jury instructions. Members of the jury, You have found the defendant, Paul Edward Westbrooks Jr., aka Paul Edward Westbrooks and Paul Westbrooks Jr., guilty of the offense of murder. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during this punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. The request must, 1, state that it is requesting that testimony be read back. 2, state that you have a disagreement about a specific statement of a witness or a particular point in dispute.
A routine bond hearing quickly turns into a tense courtroom showdown as a defendant charged with the murder of 4 people asks the judge for a second chance. After spending nearly 7 years behind bars, he hopes the court will reduce his bond so his family can help secure his release while waiting for a new trial. His attorney argues that he has no criminal record before this case, no personal wealth, and strong family support. The defense claims that a lower bond would allow him to prepare for trial while remaining under strict supervision. But the prosecution strongly disagrees. Investigators remind the court that this case involves 4 victims who were killed near a college campus in a crime that shocked the entire community. They argue that the seriousness of the charges, along with the possibility of a lengthy prison sentence, creates a significant risk that the defendant could flee if released. After hearing both sides, Judge West carefully weighs the evidence. While she agrees to set a bond, she refuses to reduce it to the amount requested by the defense. Instead, she orders a $1 million bond, along with strict conditions including GPS monitoring and house arrest if the bond is ever posted. Moments later, another young defendant appears before the court, asking for his own bond reduction after being charged with aggravated assault with a deadly weapon. His attorney describes him as an 18-year-old with a supportive family, steady work history, and deep ties to the community. The defense asks the judge to lower the bond to
All right,
$50,000 so
anything,
he can
else
return
with
home
regard to
while
the
awaiting
charge,
trial.
Mr. Smith?
Prosecutors push back
Mr.
immediately.
Vasquez?
They allege the defendant followed a young woman home late at night before her boyfriend was shot during the confrontation. Combined with a prior juvenile arrest
it's all
involving
good
a
then?
handgun, they argue that releasing him on a low bond
Yes, sir.
would put the community at risk. Judge West delivers one final message that leaves the courtroom.